Hello, welcome to the third and final session of Houston Seminar's course, The Many Names of Slavery. My name is Emily Todd, and I am a member of the Houston Seminar Board. While we get settled in, I'd like to remind you that this session will be conducted in the webinar format. If you have questions or comments, we will be addressing them at the end of the presentation. You may type your questions or comments using the Q&A icon at the bottom of your screen. I'd also like to remind you that today's session will be recorded and available for later viewing by subscribers to the class through the end of the semester. Now to the introduction. Sandra Guerra Thompson is an attorney and has taught at U of H since 1990. In 1996, she became the first Latina tenured law professor in the state of Texas. Today, she is director of the Criminal Justice Institute and the Newell H. Blakely Professor of Law at the University of Houston Law Center. In addition to her teaching responsibilities, she is deeply involved in the civic life of our community. She was appointed by Governor Rick Perry in 2009 as a representative of Texas Public Law Schools on the Timothy Cole Advisory Panel on Wrongful Convictions. In 2012, Houston Mayor Anise Parker appointed her a founding member of the board of directors of the Houston Forensic Science Center, where she served as vice chair from 2015 to 2019. Her book, Cops in White Coats, Curbing Wrongful Convictions Through Independent Forensic Laboratories, which was published in 2015, draws on those experiences. A native of Laredo, Ms. Thompson received her BA and her JD from Yale University, where she was an editor of the Yale Law Journal. She writes and speaks regularly on wrongful convictions, eyewitness identifications, forensic science and crime labs, civil asset forfeiture, federal sentencing, discrimination in jury selection, prosecutorial ethics, police interrogations, and immigration crime. Her schedule is extremely busy these days as she serves as the deputy monitor for the bail bond reforms memorialized in a 2019 consent decree entered in a class action lawsuit brought on behalf of indigent defendants, arguing that long-standing bail practices violated basic constitutional freedoms. She is also the monitor for another Harris County consent decree regarding the integrity of the criminal charging process. Aren't we lucky to have her in Houston? Anyway, today we've invited her to speak on incarceration as the cultural perpetuation of slavery and convict leasing and labor in Texas. Sandy, thank you so much for taking time out of your extremely busy schedule to talk to the Houston Seminar tonight.
Thank you so much. I'm delighted to be here, Emily. It's something that I care deeply about, and I hope that it'll be an interesting program. So I guess I'll start share my screen. And here we go. So I want to talk today about racial and ethnic justice and pretrial reform in Harris County, or what a lot of people call bail reform. So this really has to do with the pretrial phase of the criminal process. So what's it all about? Let's talk a little bit about what do we mean by pretrial justice? What we're talking about here is pretrial detention, right? Holding people in jail after they've been arrested, but before they've been convicted of a crime. And at this stage in the process, they're still presumed innocent, right? And they may not have lawyers to even help them. So they're out in the world and they're carrying on their lives, and they get into some kind of trouble, and they end up under arrest and brought to the Harris County Jail or whatever jail. And what will happen to these people at this point? Right. Well, one of the things that we've seen is that from 2000 to 2015, there's been an increase in the number of people held in jails. And 95% of that growth is due to people who are being held pre-trial. So when we think about the Harris County Jail or any county jail, most people think about people being there because they're being punished for committing a crime. But in fact, today, the jails are filled primarily with people who haven't been convicted of a crime. So today, the overall jail population is 75% is pretrial detainees, people who are still considered innocent under the law. And so how does this work, right? How does it work? When a person gets arrested, what happens? Well, we know that judges might set bail, right? And so what are the goals of bail? Historically, the goal of bail was to provide some kind of incentive for a person to return to court, or some assurance for the court that the person is going to come back. So, if you think about it, like, if you were arrested, if I was arrested, and we were told, come back to court, this is your court date. And if you don't come back to court, a warrant will issue for your arrest and you'll be charged with another crime. It turns out most people are going to come back to court. But nonetheless, we migrated over time to a system where judges started to require financial bonds. And, the question then is, does that make us safer? Because I tell you, I watch the news all the time and you hear them say, the police arrested someone and the judge set bail at, $10,000. And we've come to equate that dollar figure with an amount of security, right? That we're going to be safer. The higher the bail that is set, the safer we're going to be. At least that's the assumption. But in fact, before this bail reform in Harris County for misdemeanor cases, for the low-level cases, judges used to set money bail in almost every misdemeanor case, right? So almost without exception, according to the bail schedule that was created, almost every person was required to pay money. So you think about it, well, who got out? People with money, right? People with access to money, access typically to a family member or a friend who could post the bond, they got out. And the ones who had no money, the ones who had no connections in the community to someone who could do that for them, they stayed in. So does that keep us safer? Does it keep the most dangerous people in jail? Not necessarily, right? So here's a photo from inside the Harris County Jail in 2020, in the middle of the pandemic. The numbers of people being held increased largely because of the effects of the pandemic on the jail, but also because of the use of money bail. And the Constitution has protections against excessive bail, right? So the Eighth Amendment includes a provision that excessive bail shall not be required. And going back to 1951, the United States Supreme Court, in a case that it's considered a landmark case, said, look, if the amount of bail exceeds what a defendant can pay, and if they're not a risk of flight, then that's excessive, right? So judges are supposed to take into account how likely is it that this person will not come back to court, and set a money bail that would be appropriate to assure that the person would return to court, and cannot be set any higher or that would be excessive. And the Texas Constitution likewise, assumes that prisoners will be bailable, unless it's a capital offense. I mean, that's in the Constitution. Under the law in Texas as well, courts can deny bail, not only in capital offenses, but in other cases where people have committed multiple violent felonies or violated a condition of release in the past, violated a protective order in a family violence case. So the law does take into account that someone may be a danger and that they might not be allowed to be released at all. But this use of money bail in the United States has worked to the disadvantage of the poor, and that has serious ramifications in terms of racial and ethnic justice as well. And so we see, like in 2018, of the people incarcerated in local jails, the Blacks were incarcerated at a much higher rate than others. Native Americans also at a very high rate. And of course, they are an extremely poor ethnic group. And then Hispanics and whites and others at lesser rates. So again, the growth has been in terms of pretrial detention in the jail, and then those numbers look racially disparate as well. And if you take a look at this data, this is Harris County. This is not national, but Harris County. And this goes back to 2016. We see that Blacks represent 18% of the entire community. And yet when we look at the people incarcerated at that time, 48% were African American. And so we have extreme disparity in terms of the incarceration of African Americans in 2016 in the Harris County Jail. And breaking that down further, again, we see this figure, 75% of the people in the jail are pretrial detainees. Again, people who have not been convicted of any crime. And looking at it even further, what we see, what do we know about these people? Well, we know that 48% of these pretrial detainees are considered special needs in the sense that they have diagnosed mental illness or homelessness. And of those, a staggering 61% were African American. So it gives you a different picture of the pretrial detainee population, that not only is it predominantly people of color, mostly African Americans, but of those, then a very high percentage are people with mental illness or homelessness. Again, you know, when you're talking about the poorest people, these are people who tend not to have the resources for housing and tend not to have adequate health care and have a lot of health issues. So prior to bail reform in Harris County, over half of all misdemeanor defendants spent more than a week in jail pre-trial. That's a huge number when we're talking about people charged with the lowest levels of offenses, spending more than a week in jail pre-trial, over half. So money bail, this use of money bail, one of the things, you know, that I really have come to believe is that it just doesn't work. It hasn't worked. If we set money bail based on the charged offense, right? So the police decide they're going to charge someone with a particular crime, and we set money according to that crime, we inevitably get it wrong. We inevitably get it wrong on who stays in jail and who is released. Because again, a decision to set a money bail is a decision to release, right? That's effectively a judge saying, you can be released as long as you pay a certain amount of money. And courts don't usually know how much money a person might have access to. They don't know whether the person is going to get out or not. And so when they set $1,000 bail, they might assume that the person is going to get out. And maybe they will. But maybe even $500 is too much for a person who is homeless or has mental illness and doesn't have a job or other resources. Oftentimes, the people judges think will be released do not get released because they're too poor, and they get stuck in jail, right? Who are they? They're, like I say, they're the homeless people, mentally ill people. I had a sheriff's deputy tell me there were many foster kids who would get stuck in jail, as well as veterans. There are many veterans who fall into several of these categories, and women disproportionately will end up getting stuck in jail because they don't have the money. On the other hand, even when we set higher money bail for people who we consider dangerous, one study showed that half of those people are going to get out because they come up with the money. If we set a $50,000 bail, how much does it cost for them to get out of jail? Well, if they're using a commercial bail bondsman, it's going to be 10%. So you're talking about coming up with $5,000 on a $50,000 bail. So when the newscaster says the judge set bail at $50,000 and we all feel safe, we think, oh, well, they'll never get out. They're going to be stuck. No, not actually. A lot of them will get out. And maybe they shouldn't be getting out. Maybe they're dangerous. On the other hand, maybe they should be getting out, but now they had to pay a lot of money. And that's money that a lot of these people really couldn't afford to pay. That's money that would have been used to pay bills, to hire a lawyer. Now they're going to have to ask the court to appoint a lawyer because they don't have any more money. So we get a lot of the wrong people being released. And at the same time, we have a lot of people who really should be getting out who don't. And what happens when they get stuck in jail? Like I said, before bail reform for misdemeanors in Harris County, 50% of the people spent a week in jail. What happens in that time? Their kids are unattended, they lose their jobs, they may lose their homes. And again, this is a major study that was done by the Laura and John Arnold Foundation, and they found that just 2 to 3 days in jail is enough to cause a person who would otherwise not have committed a new crime to commit a crime. So by jailing people unnecessarily, we actually increase criminality. And why is that? Again, it goes back to, well, what happens when you get stuck in jail for 2 to 3 days or a week? People's lives fall apart. Whatever tenuous situation they had in terms of housing and jobs and relationships will tend to fall apart. And they're dealing with the trauma of incarceration. It's very dangerous to be in jail. In Harris County, 55 people died between 2009 and 2015. They die for many reasons. They die because they're sick when they go into jail. They die because they're depressed, suicidal, or because they're assaulted, or have other, are restrained by correctional officials and may die in that manner as well. So for many reasons, people can die. And another thing is that when a person is detained, they're much more likely to plead guilty. And I'm going to talk a little bit more about this. But when they plead guilty because they're in jail and they're anxious to get out, they end up getting longer sentences. They end up not having their cases dismissed at the same rate as people who are out. And they get much longer sentences, twice as long. And again, the racial disparities are much greater when we have a money bail system that keeps the poorest people in jail. So this is from the news, an inmate who died in his cell, a young man just last year. And there are many such cases, all too often, of people dying in jail. And again, most of the people in the jail are not there for crimes. They're not there for having been sentenced for a crime. They're there pre-trial. So when a person is able to get out of jail, what are the advantages? Well, there are so many, right? First of all, they can just show up to court every month. They're working with their lawyers. Their lawyer says, this you need to be in court at this time. They can dress nicely. They stay out of trouble. They're meeting regularly with a pretrial services officer. This is a county official who keeps tabs on them while they're out. And they may have other requirements, like they might have to wear an ankle monitor, or they might have to have some kind of a device, an interlock device for their vehicle, so that they don't drive drunk again. And so they have these opportunities to behave well while they're out on release. They might make restitution for a victim, start taking a class or treatment, and they're helping their lawyer investigate the case. And this is really important because, the lawyer might discover that the charge is greater than it should be, or that the evidence is not so strong after all, and in fact, they might not even be guilty at all. But if a person is in jail, it's much harder for them to work with their lawyers. They don't get to see their lawyers as much, and they don't get to work on their cases as much. So a lawyer is in a much better position to take their time to work on a case, to watch the police officer's body cam videos, and really, get all the documents in the case and negotiate a plea or ask for a dismissal. And you just don't have these things. The lawyer and the client are not rushed, so they can work through the cases and achieve a more just result. Whereas if you're in jail, there's enormous pressure on a person to plead guilty. So again, keep in mind that under the money bail system, the people who are getting stuck in the jail are the poorest, and the people getting out are the people with access to money. And the ones with the access to money then have all these advantages, whereas the poorest people, not necessarily the most dangerous, just the poorest, end up in jail where they're feeling enormous pressure to hurry up and plead guilty. Yes, they can wait for their case to be investigated, but it could take weeks, it could take months. In Houston, we had a little natural experiment that occurred because the Houston Forensic Science Center, your local crime lab, decided to run the drug tests for people who had already pled guilty in drug cases where the lab had not yet tested the drugs. And when they did that, they discovered that there were hundreds of cases where people had pled guilty to felony drug charges and they were wrongly convicted. Either there were no drugs at all, like what the substance the police thought were drugs were not drugs, or they were the wrong kind of drug and they should have been sentenced less, or it was a different amount. There were many, many issues that were discovered, and about 300 people were wrongly convicted on felony drug cases. Again, a big reason why they pled guilty is because high money bail was set in their cases, and their lawyers were telling them, the police think that this substance was cocaine. They were using these drug tests out in the field, and these were being used around the country. So they pled guilty in many cases, even though they knew they didn't have drugs, but they needed to get home and back to their lives and couldn't afford to spend months in jail. So here's a clip from the article in the Chronicle about this. It received national coverage when these wrongful drug convictions were discovered. So do we have to choose between safety and justice? Or is there a way to do both? We don't have to choose, right? We can have a safe system that protects the most vulnerable people without necessarily relying on a money bail schedule. Judges have many tools at their disposal to keep dangerous people off the street. Like I said before, for many cases, the law allows the court to just deny them bail at all. In capital cases, in family violence cases, where they've violated protective orders and the like, judges can deny bail, or judges can also require close supervision, right? So again, we have pretrial services officers who can use GPS tracking, they can use many other tools, they can have continual reporting to the pretrial services officer to keep tabs on them, and place other conditions like protective orders and the like. So in Harris County, what we have in terms of bail reform, you often hear people talking about bail reform, and they often try to make us afraid of it and tell us that this is the reason why there's more crime happening. And it's actually not the case. The new rule under this federal court consent decree only applies to misdemeanors, first of all. It only applies to low-level offenses. And what it does is to enable most people who are charged with misdemeanors to be quickly released without having to pay money. So you no longer have this situation where people with money get out and the poorest people do not. Most people now can get out without having to pay money. And if they fail to return to court, again, they're going to face an arrest warrant for a new charge of not appearing, and they'll not be eligible for immediate release again when they are rearrested. So there is some kind of teeth behind this release. It's not a revolving door, because people will face consequences if they don't show up. And by the way, I should also mention that there are several categories of misdemeanors that are not eligible for immediate release. And those include multiple drunk driving, if you have a second drunk driving or more, family violence cases, situations where a person has violated a protective order, has not appeared in court, and the like. So there are a number of carve-outs that are not eligible for immediate release. And this is the website for the Independent Monitor, who is Brandon Garrett of Duke Law. I'm the deputy monitor, and I assist Brandon, and I also work closely with people in the community. So this is our whole team. There's a lot of data that the team collects that I want to share some of that with you. I think you'll find it really interesting. We also have a community working group. This is the list of individuals who represent many different backgrounds and perspectives, from law enforcement to immigrants' rights and women in the criminal justice system. We have individuals who have experience themselves with the criminal justice system, and they help us to guide the county. So one of the things that we've seen is, under this consent decree, we're working directly with county officials, with officials from the courts, from the sheriff's department, sheriff's office, as well as the Justice Administration department, and other county agencies, the county attorney's office, district attorney's office. They're all working cooperatively with the monitor team to transform the way that misdemeanor bail works in Harris County. And we've been at it for a year now. We started March 3rd of 2020, just as the pandemic was hitting. So most of the work has been done remotely, but it's been incredibly productive. As I say, this community group is also advising us and advising county officials, because the goal for Harris County officials, and this is really the only reason that Professor Garrett and myself were willing to do this work is we knew that the people we would be working with in Harris County were really committed to making this system work, to bringing about more justice for the poor, for the most vulnerable, and at the same time, keeping the community safe. So what are some of the changes that we've seen? Like I said, under the prior rules, bail was largely set according to a fixed money bail schedule, regardless of how much money you had or didn't have. That really was not taken into account. There were no defense attorneys there to help people. There were only prosecutors available at these hearings. People who were arrested didn't have the ability to speak. These hearings were about 1 minute long. They were applying a schedule, and that was the end of it. And so under that system, half of misdemeanor people charged with misdemeanors ended up in jail for at least a week. And they were the poorest and the most vulnerable. And very expensive, by the way, for taxpayers, because when you're talking about people with serious mental health issues, drug problems, these are individuals who cost the money a lot in terms of medical care, for psychiatric care in the jail. Under the current system, we no longer follow a money bail schedule for the misdemeanors, right? And again, this current bail reform only applies to the misdemeanor cases. There's another pending lawsuit for felonies, but that one has not been decided. We don't have anything to do with that. There's currently no bail reform applicable to felonies. But under the misdemeanor system, in the misdemeanor system, there's no longer fixed money bail. And most of the people, like I said, are released on what's called a personal bond or a general order bond. And this type of bond does not require them to pay any money. So here, if they don't qualify for the personal bond and for immediate release, because if it's a second DWI, if it involves family violence, or there's a prior violation of a protective order, and a few others, for those situations, then judges are required to take into account a person's ability to pay. They can set money bail. They can set many other kinds of conditions of release. Like I said, interlock devices for DWI, or GPS tracking, or reporting regularly to a pretrial services officer. And now they have defense lawyers helping them. So defense attorneys and prosecutors are present at these hearings, and they have a real hearing now that lasts about 7 minutes long. So it's real justice at the pretrial phase, rather than just a mechanical following a schedule situation. So I wanted to just run through some of the numbers that we have been seeing. First, let's just take a look at misdemeanors over time. And one of the interesting things that we see is that even before the lawsuit was settled in 2019, there was already a trend in Harris County, this is for Harris County, to charge fewer misdemeanors. And that's a choice. It's a choice that's made through police policies. It might be that there is an issuance of a citation instead of an arrest, or not arresting people at all, not charging people in any way. It's also due to changes in the district attorney's policies. And I know that District Attorney Ogg is proud of the programs that have been put into place to divert people. So instead of charging them with a misdemeanor, they will be given an opportunity to to take a class, to engage in to do some other agreed behavior, and have those charges not brought in the first place. So for a variety of reasons, and I think also the pandemic in 2020, We see fewer misdemeanor cases overall. So people always ask, okay, well, now that you have this bail reform in misdemeanor cases, are there new crimes being committed? And one of the things that we see is that when we look at new offenses committed by a person within the first 90 days, within 180 days, within the first year, we see similar or even slightly lower numbers of crimes being committed by misdemeanants. So the rule went into effect in 2019, and we see that there are fewer people being charged with a subsequent offense in that time. So this is a share of misdemeanor cases with a new felony crime. So these are cases where misdemeanants are released, they're charged with a misdemeanor, they're released, and then they commit a serious felony. And there are a fair number of those, but again, the numbers are pretty stable over time. And we continue to see that in the 2020 numbers as well. So who are the people who are committing new offenses, who are, misdemeanor arrestees that are released? We see a significant percentage of them being homeless or people with mental health issues. And so, Professor Garrett often says, we think about reoffending, we think about a new arrest upon release a little differently when we learn that the people we're talking about are homeless or have a serious mental illness. And that's who we see committing the new felony offenses as well as new misdemeanors upon release. Which, again, what's the solution to this? Is it to impose money bail? Or should we be thinking differently about the root causes of this kind of criminality? So this is a graph that shows the duration of pretrial detention. And one of the things you'll see is that, in 2015, 2016, you had higher rates of detention. I mean, we never had extremely high detention rates, more than 14 days. There was always a relatively small percentage of people who were being held for a week or 14 days in a misdemeanor case. But of the people being released from 0 to 1 days, like immediately, that percentage has grown dramatically. And it started growing even before the consent decree. There was a lot more awareness in Harris County about this issue. There was growing public sentiment that that people should not be held in jail just because they're poor, when they don't present a risk of flight or a risk of committing a violent offense. And so we see those numbers going up, and they've continued to go up even in 2020 with the new rule in place. Okay, so again, I said there are a number of categories of misdemeanants who are not eligible for immediate release. And we see these numbers reflected here. And so this is, basically the same, like nothing has really changed for these people in terms of what the judges could do for a repeat DWI, for a domestic violence case. The judges have all the same tools at their disposal. They can set money bail, they can set other conditions of release, etc. And what we see happening, though, is larger numbers in these cases in 2020. So we have relative stability, then an increase in 2018 and 2019. Again, 2018 is before any kind of bail reform. Those numbers just were going up in Harris County of people committing these misdemeanors. And during the pandemic in Harris County, we see a spike in terms of these kinds of arrests. Especially you see their domestic violence increasing pretty dramatically. And that's a trend that is being seen around the country. Again, has nothing to do with bail reform per se. It's just a result of the pandemic, apparently. So, what about race? As I said before, the use of money bail has a racially disparate impact and had a really serious impact in Harris County in terms of creating an enormous racial disparity. Well, we see that those disparities are decreasing. So if you look at people who are released on bond today, the disparities as compared to 2015 are dramatically reduced. And if you look at people being released without requiring money, people released on a personal bond, personal release, or a general order bond, again, those are without any money. That's the graph on the right. We see almost parity between Black and white. One of the challenges with the data, however, is that it doesn't track the Latinx population in any meaningful way. But the monitor team and our data gurus have been estimating that. And so these statistics show the data with regard to the Latino population, the Latinx population. And we see figures that show greater increase, an increase in pretrial releases for Latinos without requiring money bail. So some of the other system improvements, like I said, we've been working closely with county officials, and there's so many things they've been working on. One of the things is we know from studies that if you want people to come back to court, the number one thing you have to do is send them a reminder. So this isn't any different than when we get reminders from our doctors or a dentist saying you have an appointment tomorrow. It's very effective at getting a person in to make that appointment. And again, if you think about the people who are being arrested, this is not a group that is necessarily the best at keeping appointments and being on top of their calendars. So now they're going to get electronic court notifications. This is a new system. It's going to be implemented via email, text, and voicemail, and translated. One of the things that we found is that there were very few things being translated. Yes, they had translators in court, usually, depending on the language. Some languages are hard to find translators, for these bail hearings. But in terms of forms and notices, there weren't translations. So that's happening now into multiple languages. Public defenders, again, are representing people at the bail hearings. For the ones who are not eligible for immediate release, they're having a more robust hearing where they have a lawyer helping them. So they have a real bail hearing. And again, there is a requirement for most people to report to their pretrial services representatives. And now they're able to do this remotely. This was a change that was forced on the county really by the pandemic and the need to keep everyone safe. But it's a good change. It's a good development because Harris County is enormous. And so you think about the burden it puts on a person if they have to go all the way across the county, this enormous county. These are people who have trouble with daycare and transportation and the like. So having the ability to report remotely to their pretrial services officer is going to help people to fulfill their legal obligations. And now under the new system, there's going to be more of an ability to reschedule a court date or to have the lawyer appear without the client also being present. And again, this enables people to go on with their lives more successfully in the pretrial phase and not have their bail forfeited and have an arrest warrant because they weren't able to get to court on a certain date. Most of the times when people don't come to court, it's not because they fled to Mexico or to another state. Most of the times it's just because something happened in their lives that made it impossible for them to be there, or because they just didn't realize that they were supposed to be there or where to go. So the new system is going to make it much more likely that people will be able to fulfill their legal obligations. I just want to say one other thing, though, because like I said, there is a lot of, there are statements that are made in the press when a crime is committed by someone who was out on bail. And people start talking about, bail reform as being a bad thing. And one response that we're seeing in this legislative session is Senate Bill 21 that was filed by our Houston Senator Huffman and our Houston Representative Paul Betancourt. And I just wanted to tell you all a little bit about what this bill provides. It requires immigration status to be determined and considered in deciding bail. This is not something that is currently an issue in the way that bail practice is done, unless it already is taken into account if there is a hold on a person, a hold that is placed by the Immigration and Customs Enforcement. So it's already happening in a lot of cases, but this requires it to be done in every case. The bill also explicitly permits bail schedules. So it makes a point of saying that having a schedule, a fixed money schedule, is okay under the law. And it restricts the authority of the magistrates or the justices of the peace to set personal bonds. That is, it really makes it hard for the sort of the line judge, right? The first judge that a person sees to release a person without requiring that they pay. It requires that they set money bonds in most cases. So it's a huge change that this bill would require. And then it says, we understand that bonds might be unaffordable. So if it is unaffordable, they can have a hearing within 48 hours. So they're going to have to wait another 48 hours to have a hearing before a judge. So the first judge would use a bail schedule or simply impose a money bond according to the law, right? And then the next judge would have a hearing on that within 48 hours. So by now you're really talking about a person being in jail for quite a while. And it says anyone who ends up stuck in jail for 4 business days. Now, a lot of people get arrested on weekends or late on Friday night. So those weekend days don't count. Then 4 business days more, if they're still in jail, then they can have a hearing to reconsider their bail. That doesn't guarantee that their bail will be changed, but it says that they get a hearing. And finally, I just wanted to mention also that one of the things that has happened as there's been growing awareness about the problems with the money bail system and how the poorest people end up stuck in jail, even though they don't present any risk to the public. So one of the things that has happened is that some organizations have been created to try to help those people. And so they raise money and then they post the bail for people. So the judge says, you have to pay $2,000 to get out of jail, and these organizations will show up and they'll put down the $2,000 and pay the bail so that the person can be released. And if the person goes to court as they're supposed to, then at the end of that process, when the case is resolved, the organization would get most of their money back. Well, this bill restricts what those organizations can do. So it's requiring that they register, that they provide their donor lists, that they must have an office in each county in which they work. So if you have a Texas organization serving all the counties, now they're going to have an office in every county under this bill. They would have to go and open offices in every county. And they can only bail out misdemeanors now, it says. So a judge says you can come out of jail on a felony charge if you pay $10,000. This is now going to make it illegal for an organization to say, okay, I believe in this person, we're going to put the money down. And even in the misdemeanor cases, they cannot post anything more than $2,000. So it's pretty restrictive for these kinds of organizations. So I just wanted to bring that to your attention because it's currently pending. So with that, I will thank you for the opportunity. It's been my pleasure. I've been working in this area for many, many years, and it's it's a cause that I care deeply about. And I really believe that if we study the issue closely, what we see is that we can have a system that works for the poor, works for the taxpayer, that keeps us safe, but it has to be a rational system. I'm really excited about the work that we're doing in Harris County right now, and I'm grateful for the opportunity to share this time with you. So thanks for coming and listening, and I'm eager to get your questions.
Thank you so much, Sandra. I'm Rainey Knutson with the Houston Seminar. Thank you all, and just want to invite attendees to please submit your questions via the Q&A or the chat at the bottom of your screen, and we will get these presented. I wanted to start with SB 21, since you ended with that, and I think it's fresh on the mind. Two questions on that. Well, the first question would be like, what do you think are the chances of that passing in this legislative session?
Well, I confess that I'm not following it closely. I'm not keeping tabs, but I'm afraid it has a good chance of passing. Mm-hmm. I know that Harris County officials have recently testified against it. They have a fact sheet out for the public. I was studying that earlier today. They estimate that the cost to Harris County could be upwards of $100 million to implement this kind of new approach, because there's a lot of changes that they're going to have to make. So, I know that they're opposing it, and that counts for something. Certainly, it's the largest county in the state, but politics at the state level are very different than politics at the county level. So, yeah, I think I'm glad to have the opportunity to, just to inform everyone about what the bill states, and
I'm curious about the charitable bail bonds organizations, and why would they include that? Is that something that is perceived as, or actually is being abused? Like, I can think of somebody who's a member of a drug cartel getting covered by a charitable organization, which is really the drug cartel paying it. Is that what they're thinking?
I don't think so. And I'm not entirely sure where that is coming from. The only thing I can think is that if judges are setting money bail with the hope of keeping a person in jail, then these organizations would frustrate that. And so it seems like, when you look at what the law does, it will have the effect of making it much harder for these organizations to bail people out. I mean, it's interesting, right? Because in the this money bail issue has been around for a long, long time. You can go back to the 1920s and find blues songs talking about, I'm stuck in the county jail because I can't make the money for bail. And in the 1960s, the Vera Institute of Justice did a study. It was like an experiment that they did. And they said, look, all these poor people are getting stuck in jail because they can't afford the bail. What would happen if we bail them out? And so they just started paying the bail. And they didn't tell the people that, that it was them bailing them out. They didn't tell anybody. They just went to the courthouse and they started paying bail on people. And what they found was that people showed up for court. Of course, there's going to be some who don't. But that's going to be true, of the people who are paying their own bail, right? So it's not like this is changing that. But anyway, I'm not really entirely sure where that sentiment is coming from, other than maybe a view that it undermines security by allowing them to release dangerous people. So that's probably what it is.
I'm interested in the intersection of laws at the state and federal and local level, or initiatives at the local level, and particularly the First Step law that passed a couple of years ago, I think, under President Trump. And will this SB, would this state bill interact with that? Does the First Step law have a bail provision? I guess first of all, who gets to decide this stuff?
Yeah, so First Step, my understanding is primarily applies at the federal level. And federal bail is a whole other thing, because federal offenses are generally much more serious. So what ends up happening in the federal system, they talk about, well, we don't use money bail very much in the bail system, in the federal system, and that's true. But what they do is they just deny bail altogether in the federal system at a pretty high rate. That's kind of a whole separate thing. Now, this is state law, and really the states and the counties are the ones that do most of the incarceration, because most of the criminal cases are at the state and county level. It would apply obviously to all the counties in Texas, including Harris, which is complicated by the fact that Harris County is under this federal court consent decree. So I imagine that there would end up being a lot of litigation, and this is where a lot of the cost would come from that the county was talking about. It's going to cost the county a huge amount to figure out how all of that's going to work, because a federal court decision would supersede any state law. So they can't undo the federal consent decree by state law, because federal law is supreme to state law under our system of government. But there would be a lot of litigation about it, inevitably.
Is there any kind of incentive within the system outside of just bail bondsmen themselves? But is there an incentive for maintaining the bail system, a financial incentive? I'm thinking of like judges having to raise money for their reelections, or where are the incentives for keeping bail other than this idea of safety?
At first I thought you were asking me if the use of money bail creates an incentive for people to return to court. That's one issue. But I think what you're asking is really what motivates the officials, right? Legislature, judges, et cetera. And I think it's primarily at the legislative level where we see the bail bond insurance industry having a lot of impact, because you know, we're all familiar. We've all seen the bail bondsmen and their offices near the courthouses and near the jails. These are small business people, and effectively what they're selling, their product, is an insurance product. And so just like your State Farm or Allstate representatives who may have a small office in the community, but they're really backed by national insurance companies. And the bail insurance business is a huge business. And not only, do they make billions of dollars, but it is the most lucrative form of insurance product that they sell, because they almost never have to pay out any money on these insurance products. So, when you buy car insurance or homeowners insurance, there's a much higher chance that the insurance company is going to have to pay out and pay out substantially. Whereas with bail, they don't. So what happens is, like I said, an individual will go to a bail bondsman, bail bondswoman, and pay a 10% is this typical fee, a non-refundable fee. So that's just money that the bondsman keeps for providing this service of posting the bond with the court. And that's where the insurance comes in. So they post the bond for the full amount, the whole $2,000. What happens if a person doesn't show up for court? Are they going to have to pay? The answer is most of the time, no, they don't, for a variety of reasons. But again, the laws are structured in a way that tends to help them not to have to pay. So, there would have to be a separate action for the county to go after the bondsman company for the full amount of the bond. But that would only happen if the person is not rearrested in 30 days, for example, under Texas law. If a person gets arrested again in 30 days and they're in custody again, then they don't have to pay the full amount. And so a lot of times what would end up happening is, they'll get arrested by HPD, and then the bond doesn't have to get paid. Or they show up to court on their own or whatever. And even if ultimately they are required to pay, one of the things that we have seen, the Houston Chronicle and the Dallas Morning News have done studies in these two cities, and they found tens of millions of dollars of unpaid bond forfeitures. So for a variety of reasons, it's extremely lucrative. And does that matter in terms of politics? Absolutely. Absolutely. It's very, very hard to get any kind of meaningful bail reform passed at the state level that would address the kind of issues that I have been talking about. And there have been efforts with lots and lots of momentum and support from the Chief Justice, Nathan Hecht, who's a Republican, and has been very vocal, trying to advocate for changes that would further pretrial justice. But we've been unable to get those to happen.
We have several questions about services to incarcerated people while they are incarcerated. The first relates to our previous course in this, or class in this course, which Jay Jenkins talked about how Texas is one of 4 states where incarcerated people are not paid for any work that they perform.
Mm-hmm.
Do you see any chance of that ever changing?
I sure hope so. I have taken my students on tours of Texas maximum security prisons for the last 30 years, up until COVID. And they used to get paid. When I started going to the prisons, they used to get paid a small amount. And that was important because a lot of people don't have family members to put money into their accounts where they can buy things at the commissary in the prison, and that money is really important to a prisoner to be able to get snacks or to get a heater. They'll sell them little heaters, believe it or not, reading materials, writing materials, postage stamps, a lot of these kinds of things. They don't have money for them unless they somehow have access to a job where they can earn it, or a family member to give it to them. And so I view it as really quite cruel not to allow that. And it used to happen, and some legislator found out about it and decided it was a bad idea, and so they stopped.
We have another question related to mental illness, which you kind of briefly touched on. What kind of services are available in jail, and continuity of care after people are released? And do you think those services are sufficient?
There's often talk about the Harris County Jail being the largest mental health facility in the state, and I find that to be very sad and also very troubling, because a jail is not a mental health facility. It's sort of the opposite of a mental health facility, because these are very unhealthy environments. But there is a dedicated staff there that does their best to try to provide medication for individuals in the jail and keep them stabilized while they're in the jail. But jails they're not healthy places. These are not places where there is outdoor recreation, where there's no program available. There aren't programs. There are no jobs. There are no really very, very limited in terms of any kind of healthy activities for people, and so they really are not intended to be long-term, long-term facilities. They should be very short-term, but some people end up stuck there for quite a long time.
Somewhat related to that was a question about people sort of who are within the process of getting through their crime that they've been before conviction, before any kind of trial or whatever.
Yeah.
Regarding transportation services, do we offer any kind of transportation to people, childcare, the things that a person might be coming up against in terms of returning to court?
Yeah, well, the consent decree is really comprehensive, and it does task the county with thinking about these kinds of things, of figuring out if people don't come to court, why is that? And can we try to address it? So we have talked about transportation as one concern. I know that there have been some efforts to provide like taxi vouchers for people to get home from jail or to come back to like when they're released from jail, to have somewhere to go, a bus voucher, that sort of thing. But are we seeing those kinds of services being done extensively? No. I mean, and it's one of the things that I have been talking to county officials about for some time, and in connection with the incredible work they're doing to try to address homelessness. We've also been talking about the need for more reentry services. So the prior question asked about continuum of care, and it's not something that we're currently really seeing in any effective way. And I think the tools are there in the medical community. We have databases. We know who the population is. We know the services that they should be getting, that they would need to get. And we know that if we're better able to connect them with these services and provide them with more support, that they will be more successful in returning to court and in not reoffending.
Mm-hmm.
So
we have a question here from Madeline. Is it Hussey? She says hello, and
Hello.
she asked it, could you say more about systemic racism in the context of your remarks, specifically, number one, the functioning of the old Houston Police Crime Lab, and somebody else actually asked about the forensic stuff, versus the new Houston Forensic Science Center in the context of racism, and then just generally the effects of detention more generally.
Yeah, well, it's an interesting question. I'm not sure I'm prepared to answer in the context of forensic science per se, but I will say that one of the concerns that people have with labs like the HPD crime lab, with a police crime lab, is a concern about inherent bias, right? Unconscious or conscious bias in terms of the work that is being done. And I know from my work with the Houston Forensic Science Center that one of the first things they did was they brought in the world's expert on unconscious bias in forensic science. They brought him from Europe, came to speak in Houston, and they devised a plan for trying to reduce that kind of bias. So one of the things is, the lab is now fully civilian. There are no police officers working in the lab. The lab is independent of the police department. It's independent of the prosecution. And there's very much a culture that's been instituted to put science first, right? To do the science, to do it well and to do it efficiently, and then let the chips fall where they may. And so I think we see, and there's much more I could say about that, but let me suffice it to say that they've implemented a lot of different measures to try to eliminate both conscious and unconscious bias in how they do their work. In terms of the bail process, that's a harder question to answer. Obviously, bail hearings are done in person, where a judge can see the individual and so forth. And so there are always concerns about conscious or unconscious racial bias in the decisions that are made. Ironically, I think they may have gone to a bail schedule as a means of making the system more efficient, and also eliminating the possibility of race as a factor. But it still had terrible consequences, especially for African Americans, because it correlates with wealth. And so, it didn't accomplish anything. So I think, one of the things that we're really excited about is that under the new rule, with regard to misdemeanors in Harris County, what we see is that the people who are getting out without having to pay, there are just as many African Americans as anyone else. And that's very exciting. And we don't see any increase in reoffending. In fact, we saw in 2020, we saw something of a decrease in terms of reoffending after release. So it's encouraging. We hope that the numbers continue to look that way, but.
I've got one more specific bail question, and then a couple of more general questions for you. But are there any other states or counties inside of Texas that are flouting the constitutional constraints against money bail?
Flouting the constitutional constraints against it. I would say that probably most of them do. I mean, most counties in this state and in most states, set high money bail without necessarily knowing a person's ability to pay, and without any evidentiary findings that amount is necessary to ensure that they return to court and to protect the public from a violent crime. most of the counties do that. I mean, they just haven't been operating in a way that is consistent with what the Supreme Court said in Stack versus Boyle, and it's gotten worse. It's gotten worse as we have come to better understand the commercial bail industry and the 10%, instead of, whereas in the past, judges would say, well, I think this person can afford to pay $200. I'm going to require them to pay $200. Today they'll say, well, I'm going to set it at $2,000 with the idea that they'll pay 10% to a bondsman. And so we've seen those numbers go up dramatically. Yeah.
I've got a question about you as a teacher. You've been teaching for a long time. What are you seeing students interested in these days? What is driving them to study the law? Do you have any thoughts about that?
Sure. Yeah. I think my students are incredibly hardworking. They're some of the most diligent people ever. And most of them, I feel like they come to law school because they want to make a difference. They're leaders, they're natural leaders. They've been leaders their whole lives, and they're leaders in their own families, and they want to make a difference. And there's been an enormous interest in racial and social justice at the Law Center, expressed by students across the board, in the wake of all the turmoil from last summer. There were many declarations made across the entire law school in support of racial justice and the cause of Black Lives Matter. And the faculty and staff unanimously also made a similar declaration. So I think a lot of my students want to practice criminal law, which makes me happy. But regardless of what they want, whatever kind of law they want to practice, they seem very eager to try to really help people and make a difference.
We have got, I want to quickly plug a course in May. It's called Exposing the Historical Structures of Racism in Houston through the Houston Seminar. And that's going to really explore sort of systemic racism in health, education, and also criminal justice. The fourth course on that, we will be having Howard Henderson. And I'm wondering how Howard Henderson has, he's an expert on the police body camera program, as far as I know. What questions would you ask Howard Henderson? What should we be asking of him?
Oh, wow. Well, he's relatively new to Houston at Texas Southern University. Dr. Henderson is definitely an expert on racial justice. And so, yeah, I mean, I think, whatever questions your audience might have, I think he'll be prepared to answer. I know he has been very concerned about issues like solitary confinement in prisons, which is something that we use pretty extensively in Texas. They call it administrative segregation, but it's solitary confinement, and it's really a terrible problem. I know that he has a special interest in that subject, but he's very learned, and he can pretty much answer whatever questions your audience might have.
Okay, and then lastly, and I had forgotten about this one, Police Chief Art Acevedo, of course, is leaving,
Mm-hmm.
and his new replacement, the replacement will be Troy Finner. Do you think there'll be any changes with the new head of the police department? What do you foresee there?
I'm not sure. I think obviously, but I don't think we'll see anything dramatic initially. Most good leaders don't come in with an agenda to make dramatic change. But I think the chief has done a good job. Chief Acevedo's done a really good job of, especially of uniting the community in a very difficult time. So yeah, Yeah, I think the jury's out on that one.
Happens. Okay,
Yeah.
I said that was the last one. The one last question just came in. This was the part 2 of the flouting the constitutional constraints. Are there other states or counties that are using the Harris County misdemeanor bail reform as a model? Are we, influencing people elsewhere?
Well, there are other places. So let me just back up a little bit and just say there are some states in this country that don't use money bail, or use it very rarely, and have a completely different system. So, Washington, D.C. is one, the state of Kentucky, New Jersey moved to eliminate most uses of cash bail. California had started to move in that direction. I think it's been a little uneven there. But there are a lot of places where that has been happening. In Kentucky, it's actually a crime to engage in commercial bail bonding. So, we don't have commercial bail bonding in every state. In fact, there are 4 states that don't allow it. So we already had examples around the country that were really quite good, very effective. I mean, I would put Kentucky and DC at the top, I think, in terms of having really effective jurisdiction-wide bail practices. And New Jersey was also doing a pretty good job from what I could see. As far as following the Harris County model, I think it's too soon to say because, we've only been around for a year. We just published the second report. So there was a 6-month report. It was very rudimentary. It was just getting started. Now we have more robust data, so we can say a little bit more. But I hope so, right? Because Harris County wants to become a model. And so I hope that they will have a chance to implement all the changes that they're planning, to get the reentry program up and running. Hopefully we'll get past COVID and the courts will get back fully into business, and the sheriff's office won't be so burdened with a growing population. So there are a lot of challenges right now due to the pandemic, but once we get past it, I'm hopeful that we're going to have a really exemplary system that other communities will want to emulate.
Let us hope so. You have any, this is sort of a general question, for people who want to learn more about prison reform initiatives, specifically in Texas. I know you mentioned the Arnold Foundation, perhaps they have things. Are there any resources or places people can go to find out what's going on, what's being tried? I know it's a broad,
yeah, right. For Texas specific, I think I would probably look to Jay Jenkins' organization, the Texas Criminal Justice Coalition. Texas Appleseed has some information as well about various programs, especially in the juvenile area. There's been a lot of work that has been done in that area. I know this legislative session, there's hopefully a bill on raising the age for prosecution of a child as an adult. Because in Texas, we consider people as adults at 19 or at 18, actually. I think at 18. And so, we'd like to raise the age at which you're automatically considered an adult for purposes of criminal prosecution, to get some of these youngsters out of the jail and back into the juvenile courts. But Texas Appleseed is a good source of information. The Texas ACLU, there actually are a lot of organizations out there, but probably Texas Criminal Justice Coalition, I think, is a great starting place.
Well, I think with that, we've wrapped up. I don't see any more questions out there. I did want to just once again take this opportunity to encourage everybody to explore the Exposing the Historical Structures of Racism in Houston course, which runs May 4th through May 25th. And that is going to, sort of be related very much to this course, which has been a fascinating look at the history and present day, effects of slavery and institutional racism here. So with that, Sandra Guerra Thompson, thank you very, very much for joining us today and for this fascinating presentation and information packed. It's been wonderful and we've all learned a lot. Thank you.
Thank you.